Hey everyone, thanks so much for joining us. My name is Jillian Young. I serve here as the president at PPR Realty, and I am really excited to bring another legal update to you. We have Justin Bailey, attorney at Godey DeVost and Cross, and Brandon Carras, who's also an attorney at GDC Law, but he is also the primary attorney for TitlePlus Closing and Escrow, which is our closing and escrow partnership that we have with PPR, our preferred and affiliated settlement service. So we are so thrilled to have both of them joining myself and Jessica Loy, your lead broker and director of agent experience here at PPR Realty. We're going to have a great discussion about why it's important to use the seller's disclosure. That all comes from a case called Johnson v. Davis. And if you're new to the business, it might be a little foreign to you about why it's important to disclose and how you can stay out of trouble and how your sellers and buyers can stay out of trouble. Because we see all too often, and you guys probably know this, that a transaction will end and then boom, a few months later, we get hit with a claim. And so I think it's important on the front end. What can agents do to assist their sellers and their buyers through the disclosure process and why that's important? So I was going to see if, Justin, you could start us off with what is Johnson v. Davis and give us a little background on what that is.
Yeah, thanks for the introduction, Jillian. And so Johnson v. Davis was a case that came about because a purchaser bought a home and they get into the home and lo and behold, there's a defect, something that they didn't know about. And when there's something like that and you're in a new home, the response for any buyer is going to be, well, what the hell? Someone should have told me about this. And why didn't I know about this? Who knew about this? And the first thing that they're going to go do is they're going to go dig into it and they're going to hear, well, you should hire a lawyer and you should sue the person who sold you the house. You should sue the agent. You should sue the people that, have the money. They got money for their house. The agents got paid in the transaction. Go sue them. So what they do is that in this case, a suit was brought. And in that lawsuit, they claimed there was this defect in the home and that the home defect was something that was known to the seller. And the seller should have disclosed it. And the case going through its litigation went through a lot of stages and ends up at the Supreme Court. And ultimately, it was concluded that in a case where the seller of a home knows or had reason to know of a defect, material defect that materially impacts the value of the home, they should have and are obligated to disclose that defect to purchasers. And that's not limited to major defects. It's any defect that would impact the value of the house. For example, in Johnson v. Davis, it was a roof. And the roof is instrumental to protecting the house. But this could be anything that impacts the value. It could be an irrigation system that's failed. It could be a well pump that is going out. It could be really anything that has an impact on the value of the house that the seller knows of or should have known about. And so that's the critical piece to Johnson v. Davis is it comes down to the disclosure. And as an agent, you may be thinking, hey, it's not on me. I don't care about this disclosure because it's the seller's job to disclose. But again, everybody gets a settlement statement out at the closing and they all see who's making money on the transaction. And who do they go to? The people they think that have the ability to pay them. And sometimes that comes down to the realtor because they're going to say, hey, realtor, you should have told me this, or you probably knew this and didn't tell me. And it comes down to what the duty of the broker is and what the duty of the agent is. And Jessica may be better to speak to this, but ultimately, as the agent, you cannot make a material statement you know to be false. Well, you may not know it, but you might get tied up in litigation to show that you didn't know it. And you're just brought in because they don't know what you knew and what you didn't disclose. So that's what's important about Johnson v. Davis.
Yeah, I have a question. Maybe Brandon, you could answer that one. If we're talking about things that materially affect the value of the property. So the value of the property, is that a subjective gray area, or are there things or does that just have to be fleshed out through litigation?
No, there's things that we know are material, like the contracts even list them. So if you have a discoloration in a wood floor in the corner of your downstairs, that's going to be considered cosmetic, and it's not that big of a deal. But if you have wood eating or destroying organisms all throughout your house and you don't disclose that, that would be considered material. Or if you have, for instance, something I saw recently I had dealt with was polybutylene pipes. The seller failed to disclose polybutylene pipes that were within the home, which I can't believe they're still around. But those pipes are terrible. They can burst and cause huge problems. And it was easy to prove that the seller was on actual notice because the HOA has been sending out memos about getting these replaced by a deadline, which was only a few days after our closing, was by the final day that they would have to have it removed. So the seller was on actual and constructive notice. It was easy to show that. They didn't disclose. They said there wasn't polybutylene pipes. There were clearly polybutylene pipes. So the seller now was on the hook to make sure that that was ultimately remedied, because that was going to materially impact the price of the home to have to replace all the piping in the back, which was, thousands of dollars. So things like this, there is a somewhat of common sense. If it's expensive and it's something that would ultimately potentially change the decision of the buyer to want to buy the home, knowing that that's not going to be an expense, yes, that is a material aspect of the contract.
Yeah. So Jessica, thank you for that, Brandon. Jessica, so practically speaking, is we have a seller's disclosure form that we encourage agents to work through with their sellers, but is that required?
Yeah, great question, Jillian. The seller's disclosure statement that's provided through your forms library, it's not a requirement to be completed, that specific document, but the importance is letting our customers and clients know that if they know any material defects that affect the value or future value of a property, that should certainly be disclosed. And I really appreciate Brandon's point on also highlighting the impact of the buyer's decision to purchase that property, because people don't really think of it that way, because we all are looking at what is our own decision in that matter. And everyone has a really completely different opinion on discoloration of wallpaper or flooring or, roof repairs. So as real estate agents, it's our best practice to disclose, and to set the expectations with the sellers that if you do have knowledge of a material defect as a real estate agent, it's our duty to disclose that. And unfortunately, whether the seller likes that or not, that is a risk we don't want to take, not disclosing that information because of those legal ramifications that can certainly come back and bite you.
So Jessica, when you're talking about if an agent knows something that they should disclose, they're legally obligated to disclose it. Do they need to add to the contract at that point to make it, like, in what way do we ratify that the disclosure happened to prove that I disclosed? Is it an email? Is it adding to the contract? What does that mean?
Yeah, it all depends on the type of disclosure. But ultimately, the goal is to show that whomever is being provided that disclosure has received and acknowledged receipt of those documents, preferably with a signature. Yeah, so there are certain forms, depending on the type of disclosure, that needs to be made. And it's always best practice to use the forms that are provided, because they'll have a lead-based paint disclosure. There's homeowners association disclosure summary form. And there are certain items that are already covered and explained in those documents. However, there are certain scenarios where we would need an attorney to draft legal language to provide additional disclosure details. But the best case for representing a listing is to allow the seller the opportunity to complete that document. And it goes through a list of questions to kind of help them think through the property that they are listing, and it gives them the ability to choose yes, no, or I don't know. And it's very important to explain to sellers that, if they have any documentation that proves yes or that proves no, that will certainly help provide that response. Otherwise, if they don't know, then they don't know. And they should certainly be speaking with their attorneys to validate whether, as a seller, if that should be disclosed or not, and relay that information to their listing agent to properly disclose it to buyer's agents who would be bringing potential purchasers through that property.
Yeah, thank you, Jessica. That makes it feel real when they're out in the field figuring out, okay, how exactly do I make sure that I do this the right way? I wanted to ask Justin, you mentioned that the rule includes things that the seller knows and the real estate agent, the things that they know, but also things they ought to know. So that to me seems like a gray area. Well, they ought to know this, they ought to know that. So for example, let's say you have a seller that is just not active in their HOA. They don't pay attention to the minutes. They have no idea that maybe they're in a condo that is subject to these assessments that we'll be having due at the by the end of the year, or there's any number of things that they aren't aware of, but they ought to be. How do we as real estate agents navigate the ought to know?
Yeah, and that's a good question. And that's really why, in a situation that really should be litigated between a buyer and a seller, it's why agents get brought in, unfortunately, because it is the gray area for the agent. You don't live in the house. You've never used the shower. You've never used the pool. You're not there generally in a pouring rainstorm to see if the roof is functioning. And so what should be known to the realtor, if we're talking about lead paint, for example, most of us know by looking, because you're going to put it in your listing, most of us know, hey, this house was built in 1970. We should probably really dig into this lead paint issue. And if you don't, then that could come back on you. But if it's a house that's built in 2010, it's very unlikely that you're dealing with lead paint unless somebody painted it with paint that was left in the garage for decades. And that's not going to be something you should have known. So there are some clear ideas or some clear pieces of information that'll help you with what you should know. And that is, if you have a home built in the 80s, you might have polybutylene piping. If you have a home that's built early on in 60s, 70s, you may have lead paint. Just because the external paint has been painted doesn't mean the lead paint's gone. It's just buried. And so there's certain things that agents can know simply, or should know simply, by virtue of the fact of when something is being built. And, there's that part. But when it comes down to what else should you know about the house, a lot of that doesn't come to you. It's what you learn. And in an agent situation, it's okay, what did you actually know? If you're doing an open house or you're preparing for an open house and it rains and you see some dripping coming through the ceiling and you go dry it up and continue about your day, well, they may discover that, hey, you hosted an open house in a rainy day. Let's bring you in and question you about that. Why didn't you say there was a leak? And that's, parties that are litigating tend to dig for something. If you have a premise and you want to find or hook someone in, you'll dig and see if there's any way to do it. And that's where you can get caught as an agent. But I wanted to bring up something that's important as well on this. And it was something that Jessica brought up. And in part, you go about, putting all these documents together, but you do something else as an agent. And it's really important because you're making a disclosure, even though you may not know you're making a disclosure. You go about and you write a narrative about the property, and you want to sell the property. So you write this wonderful narrative about a property. That's a disclosure of fact that can be used against you. So it's important to know that when you're putting that in there, for example, if you say, hey, and Brandon and I have dealt with this exact case. The agent wrote, hey, we've got a home reverse osmosis system. And it turns out that the osmosis system is under the outside bar sink only. There's no whole home reverse osmosis system. But the agent put it out on the listing. Well, agent's being sued because they wrote it's a whole home osmosis system. And so, when you write these things, you've got to be careful because you're looking into it. And when you ask the question about, what about the association? They're not involved in their association. What you can try to do is say, okay, we understand that. And what you should do is a little legwork on there. And you should look into asking if there's any special assessments. Hey, we need you to talk to the president. We need you to reach out and see if this is there so we can answer it. You're charged with knowing even though you don't really know. And so for the agent side, some of it could just be, hey, come, I need you to do this. Or if the agent has worked in an association before, they can do it and they can say, hey, you guys, I just want to know if there's any special assessments. We're going to work on this. So, I think to answer your question in the purest sense, I think the gray gets absorbed a little bit for an agent because there's not a lot of what you should know, but you should know about assessments. You should know about what conditions may have existed when the home was built. And really, you're going to learn things, especially with open houses and how popular open houses are. Agents are in these homes. And if you're in a home for 12 hours and say a bathroom doesn't work, the front bathroom, you're probably going to learn that during the course of an open house. Someone's going to use the bathroom, or you're going to have to use the bathroom in the 12 hours. And if that bathroom doesn't work, they're not going to prove you used which bathroom someone used. But the reality is that you learn information about properties. The other thing is contracts fall through and sales fall through. And sometimes, especially if you're the seller, you're learning because you've seen it. Why did it fall through? Oh, they got an inspection, and the inspection found that there may or may not be termite activity in the attic. Well, now you've got a situation where you now are aware of termites, or you've got a situation where you're aware that the septic tank is failing. You've got a situation where you're aware that there's a slow drain. And in those, that's where the agent's gray area really turns to black and white, because you know that a sale fell through because of something. You should disclose it, not only because it's going to not waste everyone's time going through a transaction to get to an inspection to have the same exact thing cause it to fall through, but you know it, and you can't make a material false statement that you know to be false. And that goes for your listing. That goes for how you answer and respond to these other people. So agents, yes, you get a little bit more black and white. We're not going to hold you to what you should know unless it's something that, frankly, you should know.
How do we reconcile that with some of the well, okay, so let's use the example of an offer falling through because of the may or may not have some evidence of termite activity. Jessica, for agents, I mean, how do agents approach that conversation with someone? Do they say, well, if the seller's like, I don't want you to tell them that, or I I don't want you to disclose the reason that offer fell through because I want to see if I can get a better offer. And do we need to have a conversation with customers right off the bat that says, hey, whatever you tell me, just so you know, I'm obligated to disclose this. How would you handle that, Jess?
Yeah, it's interesting because a lot of times we'll get questions when a scenario happens like that where our agent's asking, at this point, can we amend the listing and the seller gives us permission to sell it as is? And does that type of sale exempt the seller from their disclosure requirements? And unfortunately, it does not. There's the selling a property as is. It really does not exempt the seller from those obligations to disclose those material defects, especially now knowing that during an inspection period of a pending contract. It certainly can affect the listing of the property as far as going back active on the market. But to be honest, a lot of savvy agents representing buyers are looking at the history status of this listing. So they're already going to be inquiring why it was pending and then back on the market as well. So it's important to share with the seller and set those expectations from the very beginning that, you know, as an agent, they have a duty to disclose those items to future and potential buyers of the property. And it's keeping honest people honest. And that way there is no legal ramification after the fact. So it's important to have the conversation in the very beginning as you're going through the listing agreement. In both of the Florida Association of Realtors version as well as the NABOR version, there's a specific section that identifies whether or not, as a listing agent working with a seller, to have that conversation and expectation set in the very beginning is important, because then it'll be a little bit easier when you bring that topic back up after a contract has been terminated and these new defective items have been discovered. So it's important to disclose, because there are still buyers out there that might be okay with that disclosure or that defect and still want to purchase the property and move forward.
And I just wanted to add one thing to what you said there, Jessica. It's interesting because you mentioned it goes off and then it comes back on. And as all of you probably know, when you pull up the actual listing, there's a section on there that says confidential information. It's supposed to only be between the agents. Do not think that you could just go write in confidential information the disclosure of these of the termites or whatever you discovered in the previous inspection and think it's okay. You still have some duty to your client. You need to have that conversation. So don't go write it in the confidential information and think, now I don't have to tell my client we told people, because that will come out. Just because it says it's confidential doesn't keep it confidential in litigation. So I just wanted to, when you're putting it back on, don't think that's the spot you can hide that.
Ooh, that's a good
Great
tip.
point.
Thank you. I want to go to Brandon. And Brandon, I was going to ask you about things like eminent domain. What if a seller doesn't, let's say there's a situation where they know and there's a situation where they don't know. So county is going to widen the roads. It's been talked about. There have been public hearings and all of that. And seller A on the same street as seller B. One's been active and knows about it, wants to sell their house, and one just happens to want to sell their house and doesn't really know that this is going on. And in both cases, they don't disclose. I mean, what do agents need to be aware of and sellers need to be aware of with things that they're not, most people don't look at the local news in that way. What about those situations? Yeah,
so that's actually super pertinent right now in Southwest Florida, to particularly the railroad that's running through Bonita all the way up to Estero. Yes. I think even to like lower Fort Myers. And it's was originally a railroad and is being converted through the government project, rails to trails. And it's being turned.
Sad, by the way, because the mystery dinner train was on that and it was awesome. So mystery dinner train. But,
maybe we figure out how to keep just like a little part of the trail. Yeah. But no, I think that the question's good, and right now that is an issue that we're having right now. So if anybody's home is adjacent to that, that fun fact, mine is, our law firm is handling the eminent domain claims that are going to be coming from that. Okay. Particularly Stan Bunner, who is as smart of a person I've ever met in my entire life. I think Justin could attest to that. He's litigated many of this before, but essentially, the eminent domain ends in a taking of the government. So how it was working before is the land is a part of your land is owned, but it's really given back for use to the government. Well, when that government extinguishes that railroad, that land reverts back to the land appurtenant, which would be the ours. And so now there's these claims because they want to continue to use that land, but they already extinguished the use, and to now want to get that use back to be able to convert it to a bike trail or whatever trail, a trail for bikes, scooters, whatever you want to travel on. And so now there's all these claims. They're going to have to be made. They're going to have to go through litigation process and to get that settled out. That is something that you should definitely let the owner, as an owner, you should let the other person know that they're going to have to be going through, because there's potential looming litigation on the other side, and there's awards that can come from it too. As you know, like as an owner of a home, there's a chance you have entitlement to money because of that. Actual money for this, because you're allowing somebody to use your land, which not otherwise obligated, or you're not otherwise obligated to allow them to do. This is this, like we talk in law school, Justin. The bundle of sticks is the property rights. You have the rights, and to now surrender these rights, you're entitled to compensation. And so that the process to get that is not something that's going to be done overnight, and it's something that if somebody is buying a home, might not want to have to deal with at all. They not want to have to deal with the courts, and they want to have to go and deal with all the back and forth with attorneys and stuff. That could be the last thing that they want to involve with. And I don't blame them, but making sure the person knows of that's definitely something that could materially affect the value of the home. So definitely think that's worthy of disclosure.
Yeah, and if I could add one thing to that, just
Yeah.
when we talk about the disclosure, it's something, what you've got to disclose is something that that the buyer can't reasonably discover on their own.
Readily observable.
Correct, readily observable. And so the critical
Sinkhole,
piece
by the way, like
That's one.
are a thing here. We're just sod on limestone basically. So I mean, how?
It's true. No, you're not. Yeah.
But so I'm sorry, Justin, you were saying?
Well, no, so readily observable to the other side. And so when you're talking about something like eminent domain, that's a little bit different than Johnson v. Davis. Now, if you know about it, you should definitely disclose it. That's the right thing to do. But it comes back to something we discussed previously, which is constructive notice. And there's public hearings and public discussion about these eminent domain issues or these easement issues. Well, unfortunately for the buyer, they're on constructive notice of them. And so was it readily observable to them? Most likely, yes. And so, the duty is not as cumbersome, but, avoid, if you know something, say something, see something, say something. It's sort of similar. If you're an agent, and frankly, it may not be terrible to the value, but if you're an agent and you know something, it's better to get it out there. At least if it's, just in a simple note. That could go right in the listing in the notes section. There may be an eminent domain. There's discussions on eminent domain. Go look into the rules. You don't have to get too in depth on it. So you can use the notes for that section. But, if the case came to me, I would argue that it was readily observable and you had a duty and your agent had a duty. And so me representing a buyer or a seller, I would say your agent had the duty. Well, unfortunately, now that buyer's agent just found themselves being added to a lawsuit because a plaintiff's attorney said, well, they should have told you. It's not my job, it's their job. And that's where you sort of want to sort of, as an agent, look at it and go, look, I know that there's this issue. I'd like to make at least a little note in the listing so that the other side knows it. And that way, if anything comes up, we can always point fingers back at them. And then if you're the buyer, you can look at it and say, okay, it's there. And if you missed it, you missed it. And you're going to face the consequences. Or you could just go to the other agent and say, hey, you can put it in writing. Do you happen to know if this is going on? And now they're under a duty not to lie to you. They could simply say, no, I'm not aware of anything, but I haven't looked. And it's done. But there's things you can do to protect yourself. And a lot of it is put it in writing. If you're concerned that it may be, there may be eminent domain, you can ask the selling agent, hey, have they relayed anything about eminent domain? How are you familiar with anything about it? You can dig into it and tell your buyer. If you're the seller, all you got to do is say, hey, let's drop a little footnote in our description that maybe there's eminent domain, and we've now disclosed it. And so you can get around eminent domain in a relatively easy way.
Can I add something real quick? Do you mind, Jillian?
Yeah, of course.
So as we talked about last week, we had, I think it was the 6 P's, was a proper planning prevents piss poor performance. as he was talking, a little inspiration popped in, where I feel like there's now the D's. It's and we can make it up. I'm kind of making it up as we go, but like diligent disclosures, dodge, disadvantage, drawbacks.
Division D.
Yeah.
That's awesome.
We're gonna work through the alphabet here.
That's it. Oh, that's it. No, it's. Go
When
ahead.
my husband and I bought our home and the deed was transferred, nobody sat me down and said, "Hey, homeowner, just so you know, if you ever go to sell this property, you really ought to look at what's happening in the state, what's happening in the county, what's happening in your city and your HOA, and you really need to like all the adult type things that we're talking about." I mean, no one tells the homeowner to do all of that. And I think that's where the real estate professional needs to recognize that the average homeowner might not be so engaged. I mean, they ought to be, right? Because it's their property, but it's our job to say, "Hey, have you thought about looking to make sure there aren't any outstanding liens on your property for whatever reason, from your roof? Like, did they
Or
close
permits.
out the permit?" Yeah.
Yeah, there you go.
So any number of things, but I think that's that we're bridging the gap so that the transaction can remain smooth and to keep you out of trouble. But Jessica, I wondered if you wouldn't mind just sort of summarizing the whole disclosure aspect and what agents can do to protect themselves and bring us home to what's really important in regarding Johnson v. Davis and agents using your license to represent transactions.
Yeah, so you've heard it loud and clear that disclosures really do play a pivotal role in ensuring transparency and ensuring honesty, throughout the buying and selling process. And it's really essential for mitigating risks, but also for building trust with your customers and your clients and facilitating a smooth transaction. It's important to understand, as real estate agents, it's important to understand the different types of disclosures and those legal implications that are tied to them, because it can directly impact your experience with your buyers or your sellers, and especially the outcome of real estate transactions. And we all know nobody gets paid until the transaction closes. So we want to do our utmost best to ensure that we facilitate a smooth transaction for all parties involved to have a successful closing and a happy dance in celebration of all that hard work.
Yeah, and our errors and omissions liability insurance stays at an affordable rate the more that you disclose and keep us out of trouble.
And let me add, there's one more benefit to each of you for doing the proper disclosure and helping your client, your buyer, your seller through. The people that help someone out, or people that sat you down and told you what maybe you should have known but you didn't, is the person that's going to stick in your mind. Getting customers takes a lot of work, but it takes a lot less work just to do the due diligence and help someone than it is going to be to get a new customer, because that customer is going to remember you, that client's going to remember you. And just doing these little steps and going a little bit above and beyond for them, they're going to contact you back. It's going to be better than the coffee cup or the wine glass you leave them when they close. It's doing the a little bit extra for them will keep you a client. It's going to be less work in the long run to get new clients, because all these people know people, and all those people eventually are going to move, and you're going to be the top of their mind because the little things you did to help them out is going to stick with them.
Yeah, absolutely. Any last words, Brandon?
Yeah, Justin, should we disclose pool leaks?
Yeah, for sure. Pool leaks. If you're having to add water to your
like a
pool,
personal situation.
say something.
Death in a home. That's a big
Yes,
question we
so-
always get.
Just
Not
remember
if you
the
do a
5
seance.
Ds.
Yeah, right.
Dr.
The
Dre.
5 Ds, and we're not talking about dodgeball.
Oh, okay.
Dodge, dip, dive.
Well, thanks everyone for watching. I hope this was helpful to you. If you have any questions, you can always reach out to Brandon or Justin over at Go to Boast and Cross. And Brandon, like we said, exclusively works with TitlePlus Closing and Escrow, which is our partner settlement service provider, and obviously is attorney backed by the greatest law firm in the Naples area and even beyond. They're really, really well-run operation, able to help with a variety of matters. So feel free to give them a call about anything, any questions you have. And of course, your broker, Jessica, is always available to guide you in the right direction about what to do, what not to do, those conversations that you need to be having. We are going to up our professionalism in 2024. So let's make sure that we're doing the right things, that we are not accused of being unaware. Let's maintain our education and our ability to serve our customers the best that we know how. So thanks for watching. Have a great week.
Bye, guys.
Bye, everyone. Thanks.